The first case before us today is in re Guardianship of Margaret E. Whitmer. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping the time. Your arguments are being recorded, so please keep your voices up, remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are. Would you like to reserve time for rebuttal?
Yes, please.
And how much would you like to reserve?
Probably more than 5 minutes. It depends on my opening portion.
Well,
It depends how many questions you
Well,
have.
5 minutes is the limit, so would you like me to reserve 5 minutes?
Yes,
for you?
please.
Thank you. You may proceed when you're ready.
Okay. Alex Morton on behalf of the appellant. Morning, everyone. I am primarily relying on my brief. I think I said everything that I wanted to say in my brief, so frankly, I'm more interested in answering any questions that you may have. The only thing I will say is this. This is an important case. What we've got here is a senior citizen who signs a power of attorney to avoid probate. That, in essence, is what she did. She's trying to avoid probate, stay out of, and handle things privately. And the probate court goes ahead, ignores the power of attorney, and appoints a guardian. I don't think the senior citizens of this county and this district would be real happy with that decision. So I think
Did
that's...
your client object to the initial appointment of a guardian? Before she filed her motion to terminate, did she object to that decision?
Well, and she's sitting out there, that's Claire Whitmer, the appellant. She participated in the hearing, as you can tell from the record. She submitted her response to the application, and she made it very clear that there was a power of attorney, and she was there in court. So in my mind, the way I view a court system is when a bench
Did her
officer...
response specifically indicate, whatever she filed before the guardianship hearing, did her response indicate that she was opposed to the appointment of her sister as guardian based on the power of attorney?
I think her response indicated there was a power of attorney.
Okay.
And I think that would be enough right there. Any magistrate, judge hearing the case, when they see someone show up in court with the power of attorney, they're going to let them be heard.
Well, do you think the statute is such that a power of attorney automatically means the guardianship cannot be granted? Is that your position?
No, I mean, no, that's not position.
Okay.
Our
So
position
she
is-
showed up, did she have an opportunity to participate in the hearing for the appointment of a guardian?
Wait, I'm sorry, what?
Did she have an opportunity to participate in the hearing before the magistrate for the appointment of the guardian?
I believe she did not. You'll see no transcript indicating that she did, okay? My understanding, and I believe it's in the brief, is no. The magistrate said, no, you're not a party to this case because she didn't file a motion to interview, whatever her reasoning was, which I don't agree with, okay?
We agree there's no transcript of that hearing in the record.
There's no transcript. Everything is in the written pleadings. There's no need for a transcript. Actually, there's no need for a transcript for you guys to decide the case. There's nothing. There wasn't anything stated. It's all in the written
She
pleadings.
brought her action under 211147 to terminate a guardianship.
Right.
As the basis?
Correct.
Okay.
And I think I've got some case law in there that makes it pretty clear that's a separate proceeding. And I personally see no reason why that isn't a great opportunity to terminate a guardianship that never should have been granted.
The court doesn't, the statute indicated it can be used to terminate a guardianship that was improperly issued. That's the language of the statute.
That's one of the branches, right?
Or terminate because it's no longer needed, and in this case, I think the argument is it was improperly issued. Am I correct in understanding that? Are you arguing it was improperly issued, the guardianship, or that it?
I'm actually arguing both branches,
Okay.
both branches, whichever branch you choose to rely on.
Okay.
Right. Okay, well, if there aren't any more questions, I'm gonna just sit down because I've always heard less is more. Thank you.
Thank you.
May it please the court, I'm Todd Mazzol. I'm here on behalf of the appellee in this case, Mary Whitmer, who is the guardian of the person in the estate of Margaret Whitmer. I'd like to respond a little bit just to give a background of what happened with respect to the initial appointment here. And that is all of the statutory foundations for jurisdiction were established. Proper notice was given or waived by all the parties necessary. There was a medical examination done by Dr. Taegi at that point, which determined the statutory grounds for incompetence. Specifically, the diagnosis was Alzheimer's and vascular dementia, and he determined, in conjunction with that, that she was incompetent under the statute. There was also an investigation and a report in there that included the fact that there were powers of attorney in place. What Claire did originally was she filed with the court in a general objection to the appointment of Mary as a guardian. That basically, if you look at that actual filing made by Claire at the time, the things that she complained about were, she kind of picked at the margins of Dr. Taegi's medical expert opinion, didn't make a serious allegation.
When you use the term objection, was that an objection to the magistrate's decision, or just a filing before the hearing, before the magistrate say, I object to this person?
Your Honor, it was a filing prior to the hearing that kind of laid out the grounds for her objection. And the first was based on kind of the margins. She didn't seriously contest, in this case, the proposed board was competent. The other two things that she stated is that she didn't really want Mary to be the guardian because she believed she had a financial interest on the death of the ward. And if a guardian was appointed, she wanted that order by the court to condition that under certain circumstances that don't follow the statutory requirements and duties of a guardian. There was no argument in there that because of these powers of attorney that a guardianship was unnecessary.
Then did the appellant have an opportunity to appear at the hearing to appoint the guardian that took place in this case?
They were all of the noticed parties had the opportunity to attend what was set as a non-evidentiary hearing in that case. Nobody asked that it be an evidentiary hearing. Nobody asked that it be recorded under the requirements of 211102, that you can ask for that. Nobody objected to the magistrate's decision that was made. There was no appeal made. There was no attempt to intervene, which under the Supreme Court case of Stanbuck that's cited actually by the court in its order with respect to the termination of the guardianship, that would have made Claire a party as opposed to somebody with notice that could be there at the hearing itself. So what eventually happened was about 4 months later, this motion to terminate was filed. And this motion to terminate didn't state any new grounds that weren't before the court. You know, it basically was an attempt to substitute for what would have been a direct appeal. It didn't say that, you know, the board had returned to competence. It didn't point out anything that wasn't before the court before. The powers of attorneys were, as you see in the magistrate's decision, which the same magistrate did the hearing on the appointment and the hearing on the termination, that she in fact had these powers of attorney before her, and she reviewed them, and it was part of her determination in determining that a guardian was necessary under the proper statutory requirement of this case. So I think that kind of responds, I think, to the questions that were being asked before. I want to kind of go through the 3 assignments of error and address them substantively, and I'll address them in response to the actual issues as framed by Claire in her pro se brief. The first one is, does RC 2111-02C5 require a probate court to set forth on the record the considerations persuading it to reject the less restrictive alternative and appoint a guardian? The answer is no. 2111-02C5 provides that, and I'm quoting, evidence of a less restrictive alternative to guardianship may be introduced, and when introduced, shall be considered by the court. I filed supplemental authority with this court. I think it was just docketed this morning. I did it, actually, I filed it with the court on Saturday. It was closed, it didn't get to you. I cited in that a case called TY that was out of the 8th District, in Re TY, that talks and adopts the decision made in Re AM, which was a Supreme Court case. The question there was whether the legislative command to consider, same language, enumerated factors that an agency seeks permanent custody required the juvenile court to discuss each of those factors in writing. The Supreme Court held, and again I'm quoting, RC Chapter 2151 does not define consider. And I'm going to pause there and just state that that's the same with 2111-01 that gives the definitions under that statute. It doesn't define the word consider. I'm going to pick back up the quotation. So we accord that term its common everyday meaning. We have previously stated that consider means to reflect on, think about with a degree of care or caution. This common day, everyday meaning of consider does not encompass a requirement of written discussion or findings of fact. The In Re AM court actually said that it had reached the same conclusion with respect to different statutes in the 80s in a case called State versus Douglas, and again in the 90s in a case called State versus Cook.
What do you think our standard review here in this case for the first assignment of error? Is de novo as a question of law in this particular matter?
I think this
would appellant's argument.
Whether the statute requires written findings of fact, I believe would be a de novo question for this court because it just requires an interpretation of the statute, Your Honor. But in any event, I think that the AM case will basically decide that it gives the same rationale. It's not the same statute, but the same rationale is applicable. In this case, it should be followed. I'll now turn to assignment of error number 2, and the issue is framed by Claire's pro se brief is, she asked the court, do the ward's duly executed durable powers of attorney qualify as grounds for termination of the guardianship? Again, the answer is no. The identical question was raised to the 12th and 5th District Courts of Appeals. The first case is the 12th In Re Guardianship of Collins that was discussed by the trial court in its order. And then In Re Guardianship of Pond, which is a 5th District recently decided case that I included in my supplemental authority. Both cases held, and I quote again, while the statute requires the trial court to consider the existence of a less restrictive alternative to guardianship, it does not require the probate court to deny an application for guardianship simply because evidence of a less restrictive alternative is produced. I think that, again, is framed and is the issue is argued by the appellant in this case is determinative of the issue in this case as well. It's clear that there are grounds for discretion that the court has to determine in looking at these and considering these, but the mere fact that they exist does not prevent the court from issuing an order of guardianship.
Counsel, I just want to give you a little bit of guidance on the supplemental authority before you proceed.
Yes, Your Honor.
I know that you cited some recent cases, and of course that's consistent with why we have the rule regarding supplemental authority. But I would caution you not to go back into those cases that are older and could have been included previously in your argument.
Okay, thank you, Your Honor.
Fair enough.
When I cite the TY case and the AM, I'm just talking about the rationale that the TY case relied on. So, and then the case, actually the guardianship of Collins case, that Collins, that was actually cited by the court below. So, and then the Henry Pond is a new case. Thank you, Your Honor.
Thank you.
The third assignment of error.
Do you believe the court under 211147 had the ability court chose to do so, to revoke the guardianship based upon the power of attorney in this case. In other words, the statute allows two things. One, the need for guardianship no longer exists.
Right.
Or secondly, that the guardianship was improperly issued.
So, Your Honor, my argument to that would be that it no longer exists implies that there is a change of circumstance between when the original application was filed and now. So there are other grounds in the revised code that allow a continuing determination of competency, which the court could go through. But I think that the way the language is written, that it no longer says that you're supposed to bring to the court evidence of changed circumstances. Now, the second one, the part of whether they were issued appropriately, is kind of an open-ended language, but I think there is authority, including a case that I cited that states that kind of talks really about whether the court had jurisdiction in the first instance to issue that order. And it's not a grounds to basically, that's what I think is happening in this case, try to substitute the motion to terminate for a direct appeal that could have been brought on the same issue, and that one which is within discretion of the court to determine of whether, to appoint a guardianship when there is a power of attorney in place. So the last issue that I want to address is the constitutional issue, and I'm going to start with the fact that the actual reason that the magistrate gave in her decision for denying that is that it was untimely and improperly raised. On objections to the court, that issue wasn't addressed at all by the appellant in this case, and on that basis, the court said it didn't need to go and further determine what were the factual underpinnings of the constitutional claim. In this case, I don't think that there has been error preserved for appeal because those issues included issues such as prudential standing, that if you're bringing a constitutional issue on behalf of a third party, you have to raise and prove as part of your claim. So I think that's the first grounds and probably the easiest to dispose of the first assignment of error. But if you do get to the substantive issue, I think that is also extremely weak in this case. It relies exclusively on a 100-year-old case, Schaefer versus Haller. Since that, 75 years, and that relies exclusively on Article 1, Section 1. And that's what the appellant, the only constitutional provision that has been cited by the appellant. 75 years later, the Supreme Court issued a decision in State versus Williams that said very clearly, and things evolve constitutionally and interpretations do, and at that point the court said under Article 1, Section 1, it is not self-executing, and the language isn't such that it is judicially enforceable. That decision, again, this isn't my supplemental authority, and it was decided after we issued our brief. A case called In Re DF from the 4th District Court of Appeals cited that same language with authority and followed that ruling and said in a case like this, where the only thing that was raised by the appellant was Article 1, Section 1, that needed to go no further because that was not self-executing. If you get into the merits, if you thought that you can still get past that and use Article 1, Section 1 as a limit on governmental action, what she states actually is that the probate court committed constitutional error in basically following the command of the actual statute. In this case, the statute specifically gives discretion under the very provision that she's been citing, 211102C5, to consider these two things, to consider less restrictive alternatives against guardianship. So that is actually something that falls within the discretion and would be ordinary error brought to the court. It's not an error of constitutional dimension. That's much different than the case in Schaefer versus Haller, where the case actually was you had a person who was declared physically incompetent but not mentally incompetent, and the statute at that time said a guardianship could be imposed over someone physically incompetent. In that case, they were bringing that constitutional provision as a check against the legislation itself, and the court determined that those two things could not stand and coexist together. In this case, if the challenge really was a proper constitutional challenge, it would be to those portions of both 2111-05C5 and the power of attorney statute.
Counsel, your time has expired, so if you want to wrap up.
Okay, so she would have to bring a constitutional challenge that says that discretion within the statute is improper in a constitutional violation under the very strict requirements of when we find a constitutional violation. I don't think that would demonstrate that the constitutional violation has occurred.
Thank you, Counsel.
Thank you, Your Honor.
You'll have your full 5 minutes for rebuttal.
Thank you. I think my briefs address most of the issues that were raised by counsel for the appellate. I want to just say a few things. A guardianship, there's some question about using the motion to terminate as, it's a collateral attack. A guardianship is an ongoing proceeding. It can always be ended. It's not like it ends, the guardian is appointed, and it ends. A guardian can always be removed.
How do you do that?
You file a motion for removal, and there's...
Under what statute?
It's in the probate code under, chapter 2111. Yeah, you people...
2111-47 is how you challenge it, correct?
Pardon me?
You challenge it under 2111-47.
Right, I'm talking...
The guardianship terminated.
Yeah, our vehicle was a motion to terminate the entire guardianship. Right, we didn't just want to replace the guardian. We don't...
Right.
She signed a power of attorney, we want to terminate the guardianship. But my point is just that it's always ongoing, so it's not like this is a collateral attack.
Attorney Wharton, do you think there's been a change in circumstance in any way since the original guardianship hearing?
I don't believe there's been a significant change in her condition, no. No, I don't. I think...
In any way?
Not that
condition
I
of the guardianship
am aware of. Not that I am aware of. The issue here is that Margaret Whitmer signed a power of attorney naming her daughter Claire as attorney in fact, nominating her daughter Claire as the guardian.
And that was true at the original proceedings as well, correct?
Right. And the probate court, in my judgment, overreached.
Is an out-of-state resident in Ohio permitted to serve as a guardian?
Yes, if nominated in a power of attorney, but Claire does not want to serve as the guardian. That's why she never filed an application to be a guardian. She wants to rely on the power of attorney and avoid the court involvement, attorney's fees, filing fees, the publicity. Now, this is now a public record that Margaret Whitmer is incompetent, mentally incompetent. That's another reason why people use powers of attorney and trusts, is so that it's not public. It's not a public humiliation. All her businesses on the docket of the probate court, finances, healthcare. The standard of review on this case, in my judgment, is de novo. Judge Stormer relied on his abuse of discretion. That isn't what's going on here. She did not comply or review the termination statute. The review is de novo, and in my judgment, she was wrong.
Are your challenges to the trial court decision just statutory challenges, or are you challenging the facts before the trial?
No, I don't. I think the facts are not in dispute. I think that there were some disparaging remarks made about her son that is now deceased, and but I would take issue with those facts. But no, there's no factual issue. No factual issues here. It's strictly law, in my judgment.
And your assignments there then are solely based upon the fact that the court did not follow the law. Not
Yeah.
the court made it a
Yeah.
law and factual termination.
Right.
Okay.
Right.
Fair enough.
The constitutional issue, it's in front of you. You don't have to rule on it. The case can be decided on statutory grounds, but it's there in front of you. Schaffer versus Haller, it's a 100-year-old case, but I think it's the reason why conservatorships require the consent of the impaired person. In other words, it's why you, if you're mentally competent, you have to consent. So that Schaffer versus Haller principle is alive even today.
Is your argument that the statute is unconstitutional itself, or just as applied in this case?
Yeah, I'd say as applied. I mean, actually, it's just the circumstances of this case. I mean, given the fact that why did the probate court ignore Margaret Whitmer's wishes? It impinged on her liberty. She's free to choose who she wants to be her attorney in fact.
Do we know the probate court ignored it, and we don't have the hearing from a transcript or anything from the appointment hearing? We don't really know what the court considered.
Well, we know that the court appointed a guardian, and that guardian was not Claire, who...
So is your position then, against what I understand it, that it's been unconstitutional when a ward has the power, a proposed ward has the power of attorney to grant a guardian in the case, or should the probate court always deny an application for guardianship if there's a power of attorney?
I wouldn't go so far as to say that. I would just say under the circumstances of this case, she says, I considered it. Well, okay, I think those considerations have to be expressed somewhere. Otherwise, her decision is arbitrary, unreasonable, and an abuse of discretion.
Counsel, your time has expired.
Okay, thank you much.
Thank you both very much for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk reports will mail a copy of the decision to you on the day that it's released, and the opinions are also, of course, posted on the Ohio Supreme Court